I'm Susan Singleton. I'm an English solicitor. I specialise in commercial and business law. My law firm is called Singleton Solicitors. The website is singlelaw.com. Today I'm looking at the issue of breach of contract and in particular repudiatory breach of contract in the light of the recent advice and interview I was asked to give on ITN's News at 10. In this recession, we're now in 2011, there have been more contract disputes than ever. Frequently the parties haven't properly documented their agreements, and an awful lot of the disputes I've had to advise upon have been cases where there isn't a proper written contract. So the first piece of advice would always be get it in writing. And indeed, as I record, we've got going on in London the dispute between the two Russians, Abramovich, etc., in relation to the issue of whether or not a contract had been made, and that is just typical, although it's on a much bigger scale, of the countless disputes that come past lawyers such as me on this topic. Was there a contract? When was it made? Has there been a breach of it? I was asked to appear on News at 10 in particular to talk about the items which have been in the press concerning Stelios and indeed the proposed setting up of another airline, FastJet. Now, all we had was information in relation to that which had been put in the public domain, which is very, very limited. So what would a lawyer do? A lawyer would get out the relevant contracts in order to ascertain whether or not there'd been a breach of contract. And sometimes it's not that easy to work that out, but it will usually come down in common law, and in particular English law jurisdictions, to the question of what does the contract say? Now, English common law provides that if there's a breach of contract which goes to the root of that contract, then that is known as a repudiatory breach. And that means the other party can act as if that contract were no longer in place. And obviously they'd be advised to write to the other party if they hoped there might be the chance of some kind of remedy, of some kind of compromise over the problems and the contract therefore carry on. That's usually the better advice. But in some situations, particularly where the breach is irremediable, then it's acceptable to send a notice in writing to terminate that contract. Now, most contracts will have a clause which talks about termination and breach, and it's essential to follow what the contract says. In that particular case, of which we have very few details, there was allegedly some form of comfort letter which had been entered into and then allegedly breached, which entitled one party then to repudiate and act as if that original agreement was not in force anymore. And this issue does come up quite a lot. So you go and look at the contract, and it might well say that for material breach, or indeed for any breach, or only certain breaches, there was a right to terminate. It might be an irrevocable, perpetual agreement. You need to read the terms, and it's obviously sensible to get a lawyer to have a quick look at it first. Then you need to do exactly what the contract says. So it might say, serve notice in writing. And then you go and look at an exciting clause at the end of the contract called notices. And that clause is likely to say how you serve a notice. You can't just do it any old how, you do what it says. So it might say in writing, sent to the registered office, sent to a particular person, follow it to the letter, because if you get it wrong, you might not have properly terminated your contract. So follow that. If it says absolutely nothing, and indeed if there's no written contract, then you might find that there's still a right to terminate, because under common law, and obviously you have to check if it's English law which applies, but if English law does apply, then you do have a right to terminate for repudiatory breaches. They must be major ones. They can't be any old minor breach. They can't just be a trumped up charge or pretext. There must be a breach there. And then you should serve notice and say you're terminating the agreement forthwith for repudiatory breach. And then you can walk away from that contract. Now, the contract might have a clause saying consequences of termination, which you then usually would have to follow. And that might say certain things happen, like licenses of intellectual property will cease, or there's a handover period to someone who's newly appointed in your place. Perhaps staff are transferred in an outsourcing contract whose employment rights in Europe at least will be protected by the Acquired Rights Directive and 2P in the UK. There might be all sorts of things that happen on termination set out in the contract. If there's no written contract, then you'll be looking at the common law of breach and repudiation, etc. So those are the ways you should act if there has been an alleged breach of contract. But obviously it's sensible, once you've read the contract, found it, looked at its terms, formed your own view, to have a quick word with a solicitor. That will not take long. I can look at contracts for about half an hour, which is about £120 plus VAT, and it can save an awful lot of money later, instead of somebody making a mess of their termination and having to pay substantial damages for unlawful termination. And if someone does terminate without proper cause and without proper legal rights, then the other party is entitled under English law to be put in the same position as if the contract had properly been performed, and that probably means recovering your profit on that contract. Not your turnover, but your profit. And again, litigation lawyers such as I can easily help in advising on that. So those are the issues, the principal issues that arise in relation to termination of an English law contract. It will be much the same in the other common law countries like USA, South Africa, and other parts of the world, Australia, New Zealand, which have essentially English common law as their base. Take advice, good luck with the contract, and that's all I have to say today.